this is the very interesting point of loan to director provision. It has been differently been amended. At different times it has been amended, but now it is a fresh section because the exclusively the section has been amended and reintroduced. It has been replaced basically. So the intention of this loan to directors is to make sure that the money of the shareholders is not being passed through or covered through the concept of loan to directors, and of course the directors should not misuse their fiduciary duties and restrict the diversion of funds. So saying this, now we'll be moving to the provisions. Basically, what is the basis of this law is this section 185, loan to directors, etc. That is the name of the heading of the section. Attracts when you provide loan or guarantee or security. In short, we call as LGS. When a company provides LGS to certain category, section 185 will be attracted. So this slide, the slide which I am sharing you, is the base of the section, which says that what attracts the law is providing loan, guarantee or security, LGS in short form, by a company. Then the second question is to whom. See, it basically the fund flows from the company and to the ordinary directors at the third set, and the second set is on directors, those persons in which the directors are interested, and third one is the managing or whole-time directors. So I'll repeat again, this section is attracted when a company gives LGS, that is loan, guarantee or security, to its directors, either an ordinary director or to the persons to whom this director is interested, and third one is to the category of managing or whole-time director. So saying this, you must be very important to know the legal framework. This is the crux of this section, especially the new section 185, which has been exclusively been replaced by the Companies Amendment Act 2017. So you must be very clear that the framework of this section is the crux of this the provision. So basically, the provisions of section 195 is categorized, the restrictions under section 195 is categorized to three parts. First one is the prohibited list. That is, in the case of ordinary directors, you have no option to give any loan to the directors. Second one is the restricted list. That is the persons in whom such directors are interested. That is a restricted list which we will be dealing later. So that are the category of persons, basically in which an ordinary director is interested. And the third category is very interesting. That is permitted list, and the list includes MD, whole-time director, of course. And second one is the LGS, that is loan guarantee given in the ordinary course of business. And the third one is loan security given by a holding company to his wholly owned subsidiary company. And third one is the guarantee of security given by a holding company to his subsidiary company. I will deal with this in very detail, basically within the time frame we have. But at the same time, you must be very clear that the law under section 195, the restrictions under 195 is being demarcated into three categories. First one is the prohibited category. You can't give any loan, guarantee, security, that is LGS, to any ordinary director. Point number one. Second list which we will be discussing is restricted list. There are some conditions subject to which you can give the loan, and that list is called persons in whom such director or ordinary directors are interested. And third one is, of course, the permitted list. Permitted list is divided into four categories. One MD, whole-time directors, and second one is loan security given by in the ordinary course of business, and third one is loan security given by the holding company to his host, that is a wholly owned subsidiary company, and third one is the guarantee and security given by a holding company to his subsidiary company, not wholly owned subsidiary company. We will discuss a little bit in detail. Now each and every one we are going to discuss. Now we will see, I told you, section 195 is to be studied or understood in three parts. That was the framework which we have been discussed in the previous slide. Now we are going to discuss that in little bit detail. The first part is, of course, the basic prohibition, that is attracts to the prohibited list. No company shall directly or indirectly provide LGS, that is loan, guarantee or security, to any director of the company. Be very clear about it. Any director of our company, any director of our holding company. It's clear. So you can't give a loan that is to an ordinary director, because I told you, the prohibited list speaks about an ordinary director. You cannot give loan, guarantee, security your own director or your holding company's director or to their partner. or to their relative. So this is the first category. I repeat again, you can't give any loan, security or guarantee to your own company's director, right? Your holding company's director, right? And his such director, the framework used is such director to his partner or to his relative. So exclusively the ordinary directors category has been excluded, not your company's director, not holding company's director, not his partner, not his relative. And the second category is the firm in which that director, the so-called ordinary director or a relative is a partner. So the second category relates to a firm. What is the practicality of that firm, or what is the issue with that firm? That firm is a firm where our company is, that is called such director, is a director or such director is a relative, or is such director or his relative is a partner. I repeat again, the second category is a restriction with respect to a firm. What is the peculiarity of that firm? That firm has a peculiarity because our company's director or our company's director's relative is one of the partner in that firm. So dear well-wishers, dear listeners to the webinar, the first category of restriction which we are speaking about under section 195, that is loan to directors, is about prohibited list. It has been prohibited, you can't give. There is no exemption or interpretation with respect to that. And that category is divided into two. One is the director of our company, director of holding company, partner or relative of such director. Second category is a firm. What is the peculiarity of that firm? That firm has a peculiarity because our director or our director's relative is a partner in that firm. So that is the prohibited list. Now we're coming to the second category called as restricted. I told you, we have three lists. One is the prohibited list, you can't give loan. Second one is restricted list. That is, the list is because our director is interested in these persons. That is called restricted list. And third one is the permitted list. Now coming to the restricted list, what are included in the restricted list? A private company in which such director or director is a director or member. A private company in which our director is a director or member. And second one is the body corporate. A body corporate is very important here because the body corporate has a special peculiarity here, because at the general meeting of that body corporate, 25% of the total voting power is exercised or controlled by the so-called directors which we told. And third one is a body corporate or a board or a company or a managing director who is accustomed to act as per our direction. So friends, there are three categories here in the restricted list. One is the private company, second one is the body corporate, third one is again the body corporate or board or managing director. The first one is a private company. It has been attracted because our company's director is a director or member in that private company. Second category is body corporate. Why it is restricted? Because 25% of the shareholding pattern, 25% of the voting power of that private company or that body corporate is controlled by us. And third one is maybe a body corporate or a board or MD or whoever maybe, they are accustomed to act as per my direction. So these are the categories of three categories now. After the amendment in Companies 2017, there is only three categories of this restricted list, which is very important here because you can't give loan directly or indirectly, or security directly or indirectly, guarantee directly or indirectly, subject to certain conditions only. So what are the conditions? So I told you, the second category is called restricted list. That means there is some restrictions, but you can give. What are the restrictions? Point number one is you have to pass a special resolution at a general meeting. Point number two, the general meeting notice should have attachment of a explanatory statement that should disclose the full particulars of the transaction. And third one is that loan should be utilized by the borrowing company for its principal business activity. So friends, by satisfying these three conditions, the restricted list persons, those are persons in whom a director is interested, we can provide loan. So this is a very, very, very important little bit exemption, especially for private sector companies, especially for companies in private, joint ventures and the so-called private equity funds companies, where now this amendment is very important. 2017 amendment has thrown a light to, if you are giving to those category of directors, those category of persons in which our director is interested, you have to comply with three conditions: special resolution general meeting, full disclosure in the explanatory statement, and third one is ultimate utilization for the principal business activity. If you can do so, then you can give loans to those persons in which the director is interested. Now coming to permitted list. Friends, this is the third category. I told you first category is prohibited list. That is ordinary directors of the company. I told you. Second one is restricted list. Restricted list are three category: private company, body corporate, etc., in which we have accustomed to act. They are accustomed to act. There you can give loans provided you have to comply with the three conditions: special resolution, explanatory statement, disclosure, and utilization for principal business activity. Now coming to the third scenario, it is called as basically it is called as a permitted list. Permitted list is again divided to three category: A, B, and C. What are the permitted list? LGS, that is the loan guarantee and security, can be given by a company to its MD or full-time director. Very important, not to an ordinary director, because ordinary director comes under which category? Ordinary director comes under the prohibited category, clause A, part A. This is a permit list. Here you can give loan guarantee or security to the MD or full-time director subject to the condition, any one of the following condition. One, this is as part of a condition of service applicable to all employees of the company. See, the company already have a scheme of giving loan to all the employees, irrespective of whether you are a director or not. That scheme, by utilizing that scheme, now you can give a loan to your full-time director or MD. As you will appreciate that MD or full-time director is also an officer of the company. They are now getting this loan not as a separate thing. They are getting this loan as part of a scheme which is already there for the other employees of the company. Or you have to create a separate scheme and get approved by its members by way of a special resolution. Repeat again. Permitted list category A we are being now looking into. Category A, which is dealing with MD or full-time directors, you can give LSG, loan guarantee or security to your full-time managing directors, provided either of one condition is satisfied. What is the first condition? You are providing this loan as part of the terms and conditions which is applicable to other employees also. No issue. Or you have to create a separate scheme which has been approved by the shareholders by way of a special resolution. So, friends, this is the category 1 of the permit list. Now we'll move to category 2, that is B of the permit list. So this is again a new thing which has been introduced by the Companies Amendment Act 2017. I already in the introduction. So if somebody missed my introduction, please let you know that whole section 185 of the Companies Act 2013 has been replaced. It was amended different times, but it was replaced and now introduced as a new section. Again here, coming to third category, which we are talking about permit list. A is about MD full-time director. B is about a company which is giving LSG in the ordinary course of business. So now this is a new, very, very important concept that a company now can give loan, guarantee or security in the ordinary course of business by charging an interest rate which is not below the present prevailing yield rate of a government security. You all know that, it's a government security, is a money market instrument, and the government security, you will not get interest, we call it that as a yield. So there is some tenure for the yield. They are locked that tenure with 1 year government security, 3-year government security maturity, 5-year government security maturity, 10-year government security maturity. So we have a maturity period and we have a yield rate. So the law says a company may give LSG in the ordinary course of business, subject to condition that it should ensure that the rate of interest to be charged is not below the prevailing yield rate. Now, how will you select that yield rate? That will depend upon the tenure of the loan. The law itself gives you 4 options: 1 year, 3 year, 5 year, 10 year. So you have to look which tenure is you are going to give the loan. If, for example, if your tenure is 5 years, then you take the yardstick as 5 years maturity period government securities yield rate should be the minimum interest rate which you should charge. So that is all about the permit list B. Now we'll move to permit list C and D. That is the last two things. LSG by a holding company, 2 is wholly owned subsidiary company is now permitted. Thank God, because this was a huge issue, because you all know that a wholly owned subsidiary company's funding source is exclusive by the parent company, that is the holding company. This was been restricted in the Parent Act, that is Companies Act 2013, but when an amendment came and when a new section came, now this has been allowed. A holding company can now give LSG to its wholly owned subsidiary company. Mind you, LSG, all the 3 can be given. Second category here is, please remind you that the first one is LSG, that is loan, guarantee and security can be given by a holding company to its wholly owned subsidiary company. Second exemption or the permit list under this category, that is C and D, is A guarantee or security can be given by holding company to its subsidiary. Mind you, here there is no loan. Second category, there is no loan. See, there is no loan. First category, there is all the three is there: loan, security, and guarantee is there. That is by the holding company to its wholly owned subsidiary company. Now, second, next exemption or the next permit list is not all the three, only two: guarantee and security can be given by a holding company, and that to not to its wholly owned subsidiary company, to its subsidiary company ipso facto. Both these cases, you have to comply with the condition that the borrower company should utilize this amount for its principal business activity. Friends, before I move further, I like to repeat this thing. This is the thing which we have been discussing, because most of the interpreting people under section 185 does not demarcate this section into this. So that is why the whole purpose of this webinar, especially with the advent of the new section 185. So I repeat again, there are three lists. One is prohibited list, that is ordinary directors. You cannot give loan, guarantee, security to your ordinary directors. Second list is those persons in which a director is interested. That list is called restricted list. There are three conditions you have to satisfy. That is special resolution, explanatory statement, full information, and utilization certificate. Utilization. If these three conditions are satisfied, yes, you can give to the restricted list. Third one is no issue permitted list. Again, that is categorized into 4: A, B, C, and D. And A is MD or hotel director. Second one is LSG in the ordinary course of business. Third one is LSD by holding company to its wholly owned subsidiary company. Fourth one is only GS, guarantee and security, by a holding company to its subsidiary company. So this is the parent page which we have to look into. Otherwise, you will not get the grip of this section. So saying this, again, now we'll move to the penalty. See, penalty is a very important area, because usually students or the professional circle does not look into section 185 penalty area, which is very interesting and very important. The penalty is divided into three categories. The penalty for violating section 185 is divided into three categories. One is for the company, second one is for the officers in default, and third one is for the borrowing director person. So the third category is very interesting. This is a very unique penalty that the law penalizes the director or persons in whom the director is interested, also penalized under this section 185. The first penalty is for the company, that is 5 lakhs to 25 lakhs. Second is for officers in default, imprisonment up to 6 months or fine from 5 lakhs to 25 lakhs. And third category is very interesting, for the borrowing director or the persons who had borrowed, not by following the process of section 85. So what is the crux of this penalty is, the penalty is not only for the lending company, but it is also applicable for the borrowing entity or the borrowing director or the borrowing entity. That is imprisonment up to 6 months or fine from 5 lakhs to 25 lakhs or with both. So this is the beauty of the penalty, because the penalty is being charged to the company, defaulting company, lender company, officers in default of the lender company, and borrower director or the borrower person, so-called, who is violating borrowing this LSG by violating section 185. This is another slide which is very important. Many students and many professional people ask me, or including academicians, we discuss about the applicability of this section, to category of companies. Basically we deal with three category of companies. One is public company. The applicability of section 185 is 100%. Every public company is attracted under section 185. Private company, this is a very interesting thing. When the Companies Act 2013 came, it was very clear. Unlike the earlier 295 of the Companies Act 1956, this section is applicable to all category of company, private or public. But after the amendments and after the exemptions notifications to the private company, if you read section 195, read with the amendment notifications, read with the insertion notification, and also read with the exemption notification to the private company, see, this is a category of exemptions which is available to private company. And if you ask, sir, whether section 185 is applicable to private company, the answer is yes. Then I will say, but, because why? There is some exemptions for that. See, this section 185 is not applicable to a private company, provided the following conditions are satisfied. Especially all the conditions are satisfied. What is the condition number 1? No investment has been done by any body corporate. No body corporate should have invested in this private company. Point number two, the borrowing from the banks or financial institutions or body corporate is less than the lower of twice the paid up capital of this private company or 50 crore rupees. Mind you, the second condition is about the borrowing concept or borrowing status of the private company. The borrowing status should be well within the limit. Which is the limit? Twice the paid up capital or 50 crore rupees. If it is within the limit, then you will get exemption. And last one is very important. This private company should not have any default in repaying the subsisting loans or subsisting repayments with respect to that private company. Friends, this is very important. As you all know, most of the people will be dealing mostly in private company, and you will ask, sir, my money can I give to the directors? Yes, you can give, but you should look into this important thing. Now, private company is also covered under Section 185. But there is a golden exemption. The golden exemption is stated in the slide. Is very, very, very important. A private company will not get attracted under Section 185, provided, point number one, all the conditions should be satisfied. What is the conditions? One, it has no investment from any body corporate. Two, the borrowings from body corporate, the borrowings from bank, the borrowings from financial institution should not go above a threshold limit. And third one is it has a perfect track record of repayment of loans. So this is very important. Now coming to government company, a lot of friends may ask that, sir, what about government company? Yes, government company is also attracted under Section 195. But if these conditions are satisfied, then you will get exemption. What are the conditions? The applicability is no if the conditions are satisfied. It obtains approval from the ministry. The ministry means the ministry under which the government company comes. If it is an electronic sector, the Ministry of Industries or whatever be the sector you have, the sectoral ministry, they get approval, or from the state government, they should get approval. And there is no default in filing of annual accounts and annual return to the ROC. So friends, this slide is again very important for practical purpose. So the public company, the answer is yes, 100% applicable. Private company, the answer is yes, but it is not applicable if these conditions are satisfied. For government company, again, yes, Section 185 is applicable, but it is not applicable if the following conditions are satisfied. So that is whole area of Section 195. Now coming to, you ask me, so what's more to look into here? See, while you are interpreting Section 185, it is very, very important that you have to look into the real meaning of the term relative, because as you told, in the prohibited list, company, holding companies, company, partner or relative, the term relative is used. So it is very, very important you have to understand practically the real meaning of the term relative. Please refer Section 2/77 and you must understand the intricacies, because when you go to give a loan to an ordinary director as relative, the section gets attracted. So relative definition is very important. Then the second discussion here is actually what is loan. Even though I have been speaking for 35 minutes about the intricacies of Section 185, now we'll ask them what is loan. So whenever you study, whenever you learn, whenever you interpret practically for advisory purpose or in your company or in your studies, please refer to Dr. Frederick Adlerser Mehta, F.A. Mehta and versus Union of India 1991 70 company cases 210 Bombay High Court case, because this case clearly says the loan is very important term, and every loan is a debt, but every debt is not a loan. So this is very, very important maxim. I repeat again, every loan is a debt, but every debt cannot be treated as loan, because in this case the company sold its flat to directors and the directors repaid or paid the price of the flat with different installments. The law catched and said that this is a loan, but the court said this is not a loan, this is only a credit arrangement, this is only a financial accommodation. So something to be loaned, you have to give some money to the other person and the other person will be repaying the same with interest or without interest. In this case, F.A. Mehta versus Union of India, very important case, 1991 70 company cases, 210 Bombay High Court. The court has clearly verdicted, the Honorable Court has clearly explained the meaning of the term loan and what is a financial transaction and what is a financial accommodation. So in this case, it is been concluded that not every loan can be treated as a loan, or every loan is basically a debt, but every debt or every credit arrangement, every financial accommodation cannot be treated as loan. For our purpose, loan means lending money, repaying the same by installments with interest or without interest. These types of credit arrangements will not be covered under the loan which we are discussing in this context. Friends, I am about to conclude. I'll give last few minutes for discussion. But before I conclude, you must understand 195, when you refer 195, you have to think about three other sections or two other sections. 179.3, which speaks about again giving loan. See, 179 speaks about the powers of the board which can be exercised only at a board meeting, in which you have subsection 3. There is also a clause called, investing the funds of the company or giving loan. There is also a concept of loan. 185 which we are discussing, and 196 is also very important because you go there also you give intercorporate loan. So whenever you think about 195 as a loan concept, you have to look into 173 also, and also 186 also, because they also deal with loans to other entity, loans to other person. When it comes to loans to directors, then section 185 will be attractive. Friends, this is the end of my session. Now, any doubts or clarifications? We have 5 minutes to go. So any doubts or clarification we can discuss. Anybody want to discuss? You can ask my doubts to me. Any doubts? Any clarifications? You can ask. Don't worry. You can just open your mic and ask. So this is all about section 185, loan to directors. A big section. You have to study it in a scientific way. You have to demarcate. As I told the slides are very important. I can even share with this to you, because this is a very important area where you have to be looked into. Not only the penalty and all things, but this section is the base slide is about this one, because this is a very crux. One is that you have prohibited people, you have restricted people, and you have permitted people. Prohibited people, you cannot give loan. Restricted people, you can give loan, but you have to look into who are restricted and what are the conditions they have to satisfy. And last one is permitted thing. You can give to the MD, holding director. There is some conditions. LSD by a holding company in the ordinary course of business. LSD by a holding company to a wholly owned subsidiary company, and it goes to the list. So friends, this is any doubts, clarifications, let me know. So otherwise I can conclude. Thank you for participating in my live webinar. The video of this webinar or the same topic will be available in my YouTube channel. Any other topic which you require, which is interesting for you, please let me know, so that we can arrange live sessions and also recorded sessions. Any doubts or clarifications? Don't hesitate to ask. You can ask any doubt or clarifications so that we are clear.